The management is horrible. Nobody's come out and talked to them and had a meeting. All they want is money.
Your Honor, I have to object. She's talking about people who are not here, who she cannot speak
Well,
for.
I can speak to it because they tell me.
This is not.
Well, this isn't even, she's just blowing off steam.
You've been smug with me, looking down your nose at me. Look, I'm a very intelligent Black woman.
Friedman Real Estate, I think, Management versus Carolyn Lee.
Marlene Sherman, 369-505. I'm appearing on behalf of the police from Cheryl.
All right, Miss Lee, tell us your name.
Carolyn.
Okay, well, that's good because it's scheduled for trial here today. Last time we were here with Ms. Luckoff was January 29th. And this involves the Park at Trowbridge, which she indicated was under receivership. And the defendant said that she had gotten a letter to pay $4,600. She says she paid $4,000. And she said they told her that she owed $3,825, but she had already paid $4,000 on October 16th. So the issue is about what payments show on the ledger. So we set it for trial. It was supposed to be in February, and I'm not sure why we're here today. We must have gotten adjourned for some reason. Yeah. I thought you were the accident. That's right. So, Ms. Shaw, have you had a chance to talk to Ms. Lee about this?
So we haven't spoken today. I know Ms. Luckoff has spoken with Ms. Lee about a lot of the different hearings. I do have a witness here, so we don't have any payments from November onward. So November, no payment for November, December, January, February, March, April. We were adjourning for proof of some sort of payment that existed during the period of the transfer of the ownership, now the ownership of the
Receivership. Yeah.
So there have been no payments for any of those months since then. So regardless of the balance that transferred, there was which was contested. There has been since then $92.70 in payment.
It's true.
Okay. Uh-huh.
Because of this dispute, they never addressed the issue. This could have been taken care of the first time. But they didn't want to talk about it.
Well, let me say this while you're thinking about it, Miss Lee. I don't see how I could do this any better than you two could do it. Because if it's a matter of looking at the payments they claim they received, seeing what's there, what's not there, and if it's a matter of you saying, well, wait a minute, I paid something that's not there, you should have some evidence of payment. They should say, oh, we don't have this. Let's check into what happened with that because we see you paid this. There we go. But you all want me to figure it out. That's fine. That's why I'm here.
No payments from November onward.
Okay, so what happened to the $4,000 that she says she paid? Let me see. And I don't know when that was.
It was actually on October 17th.
Did you have that one?
So what
Ms. Shaw?
what we have here on that is copy of that. So this is a Cashier's check for $4,000. So I can ask, so I have our witness here today. And we can certainly ask her some questions about the ledger, about any payments. The information that we have from the receiver is as of October 19th. So the amount that was owing from the receiver on October 19th was the $3,825. So any payments before that would have been applied on the amount that was owing at that time.
And do you show that there was a payment before that?
What we do show is the balance of $3,825. We don't have the records before, is that correct? That's right. We don't have the records before that. But she has acknowledged that she's made no payments for November, December, January, February, March, or April.
Okay, my question was simple. Did you have the $4,000 that she said
So
she
what we
paid?
have, so You don't know.
Is that a
I
no?
mean, that's all.
Oh, absolutely. Yeah.
So let me explain this for you, Your Honor.
Okay.
So I paid in October 17th, I paid $4,000. Then when we came to.
And I was just trying to ask them, did they show that for
No,
October?
because, well, I'm not asking for them. I'm just saying I remember when we were in court, they gave me a copy. I was gonna take a picture of it, their ledger. On October 1st, 3825 is owed. But on October 17th, I paid $4,000 and it doesn't reflect the ledger. Once I paid that October 17th payment, they just continued as if I never paid 4,000.
And where's the evidence of the 4,000?
It's right here.
Was it a cashier's check? Do you have from the bank the fact that that check cleared?
Oh, it cleared. It cleared.
How do you know that?
Bring up my account. I didn't think I had to bring it because I.
Well, ma'am, we're trying to see if they got the money. So yeah, we need to see that they,
You tell me what you want to ask them, because I.
no. I want to know, they're saying they never got it.
Okay.
So then you have to show me, well, yes, they did, because it cleared the account. And you, usually,
I've never met her before.
that's okay. You don't have to know her. She's from the office of the other lawyer. But when you say you got a cashier's check, normally, isn't that a bank check?
Yeah, it's through my Chase account, yeah.
So doesn't the bank take the money and certify it as
Mhm.
funds?
Yeah.
And so, but
So what
they don't do it on a bank check? They don't,
What the bank does is they take it out my account and give me a check.
a bank check?
And they write out
Wait, not your check, a bank check.
a bank check, correct?
So then who would have the back of the bank check that shows it went through and was cashed?
Well, at the bank, they actually write their company name on there, so there's nothing I can do with this, even if I walked out the bank and.
Okay, ma'am, that's not what I'm asking.
Oh, I'm
I
sorry.
know who they made it out to, which is this company. But what if somebody made the check out and the company never got it? So we have to show that they got it and they cashed it and didn't give you credit for it. So that's why I was asking, usually you could get from your bank a copy of that check, the back of it.
Oh, okay.
It's not gonna be in your account.
Oh, I see.
See what I'm saying? Because it's not your check.
Okay.
It's a bank check.
Okay.
The bank would be able to pull that up and show the back that went through, and it would show who signed off on it or show what account it went through if it was cashed. Because right now, because there was a receiver, they only got certain records up to a certain time. So what are you looking for on your phone?
Oh, I was logging into my account and.
It's not gonna be, it wasn't your check.
I didn't know that I had to bring out my sister, just goofing up because it's a.
No, that shows you got a check. It doesn't show who received it though. I believe he got the check, no question. So, and the glitch is somewhere between the receivership and the park management, some got lost in the sauce, so to speak. And maybe or maybe not, you paid it and it didn't get put down. Could be. And then it could be the other way. I don't know yet. That's the real issue, because if you paid it or we have proof that it went through their account and they're not showing it, that's the only issue. Then you get $4,000 credit.
Well, she would still owe 92,700.
Well, she's not disputing that. She's not disputing that you haven't paid since, are you? So I think she understands that the 92 is still out there, but we still got to decide what happened to the 4.
Yeah, but
So that we can get to what.
It shows that money was deposited, was taken out of her account.
Well, she has a check there.
It was taken out. They can't write a check unless the money is there. So I don't know if you understand, check. This is I bank with Chase.
Charles, get it. What she got?
I bank with Chase. And you go in the bank and you say, I want a $4,000 certified check. If it's in your account, they take it out.
I know.
It's not
I know how it works.
Okay.
I agree, I know how it works as well, Your Honor. So if a $4,000 payment was made, it would have been made to the balance that was owing. So the 3285 that was owing would have been owing on top of that.
No, it was not.
But how do we know that?
Let me just as you cannot interrupt me, I didn't interrupt you. So when we received, why don't we, can I ask some questions of my witness who's here to testify today?
Can you ask her? You can ask her anything you want to.
Please state your name for the record.
Okay, we're not, are we getting ready to have a hearing? I'm trying to just resolve this without a full-fledged hearing. You want me to take testimony from her and have a trial?
I can't provide testimony, Your Honor. So
Yeah, but we're just kind of talking it through. Now, if we need to swear her in and have a trial, then let's do it. If that's what you want to do.
I'm not telling the court what to do. I thought you were asking for something that I can't myself answer.
Right. And so off the record, without it being a trial, she could just say what she was going to testify to in an effort to resolve it.
Your Honor, I have been, my name's Doreen Montgomery. I'm the new community manager. I've been there about 2.5 weeks. I have not met you yet. Essentially, my understanding, I've done receiverships before with managing properties. Usually any payments that are applied to that applies to any of the outstanding balance. The receiver will then get for the previous property management company an outstanding roll of what is owed. So any payments would have been applied to the outstanding balance.
Yeah,
That would have been
in a
applied.
perfect world.
Correct. In a perfect world. Do I know it firsthand? I do not, because I'm 2.5 weeks into the
Right.
community.
So the question is, she's saying it was never credited properly to her. So we don't know, and you all can't show, is what my understanding is, that $4,000 actually was credited to her. We do have the check. There's no question she got the check. And it was the remitter, Carolyn Lee, payable to Parker Trowbridge. So the question is, and I know you're saying, and this is what she said too, she being Ms. Shaw, it would have already been applied, and then this would have been what was due was the 35. We don't know. I need evidence though. So we don't know that. That's in a perfect world, that should be how it works. Yep. And then you would have just gotten a ledger of what's due. But they should have some way of verifying past payments if a question comes up.
And I agree with you, Your Honor. What I usually would request from the resident in this case is exactly what you had stated before, which is, can you go to your bank and get a copy of the front and the back of the check? The back of the check shows what was running through the check stamp.
Right.
That would have shown a stamp from whatever company processed that, whether it was Friedman Real Estate or the previous company that had it.
So why don't you all have a ledger though?
Well, the ledger we have shows that her outstanding balance.
But it doesn't show line by line what she paid when.
Correct. And some.
That's the problem for me. If I'm trying a case, that's the problem. Because how do I know where you're just getting a balance of $3,000 some odd dollars from where?
I might be able to answer that for you. This ledger that we took a copy of, the reason why I know they didn't apply it is because the $3,000,
$38.25
on here, and then it shows November, December, and then it has a total of 8,400. So they did not apply that $4,000. How can you apply October if the 3,800 was due on October 1st? I paid 4,000 on the 17th, but you still going down the line as if I never paid the 4,000. And here's the proof for that. You can leave it clear as day.
Okay, you can answer
And
that.
they have it, but now they got another type of ledger sheet. They don't have this one that we had. I saved this one. She has with other, but it's
Well-
not like this.
Sort of written right at me.
I'm sorry, but
Okay,
it's not
so-
like this.
So here it is actually, so just one.
You added the other month on there. Here you go.
I have to see it for a second. Yeah, okay, let me show you. All right, so it is the same as your ledger. And it just adds, just a second, I'm responding to what you said. It just, have a look, it just adds February, March, and April.
That's what I just said.
Right, so
Where is this paper at though, that you had?
this is just an update. There's no change to that.
This is the one we need to look at. We already know about the other 3 months. You can.
Well, if it's the same, it doesn't matter.
It's the same except.
If it's the same,
So guess-
what she's saying, Miss Lee, is it's the same as this. It's, they only added the 3 months.
Right.
So everything up there before those 3 months they added is gonna be the same.
So we just have the one issue that she raised, and we understand that, is that it stated October 1st, she had that.
Right.
We're able to give some testimony, not testimony, but just an explanation.
And what are you
So
saying?
the
now?
RD system, Your Honor, the way that it works, if it starts a ledger, so let's say you take a property and it starts a ledger in that month of October, it always puts it on the first. It's just the way that the RD system works. It doesn't mean that it was the balance as the first because they took over the property on October 19th. The system just automatically adds it on first. Oh, I'm sorry. Yardi is the internal software system that we use. It's used by a lot of property management companies to go over the records. It's a resident ledger, it's our work orders, everything in the system.
Okay.
I would say, as I said, I wasn't here, but I will say that usually what I would normally request from the resident is that check. That allows me to do the research on my end to find that out. I agree with what you're saying. If you're saying that it's only gonna have a role with just the numbers, sometimes receivership will ask for the full ledger for every
That's
single
really,
resident.
that's what you need for a trial is a full ledger because I don't know what 3825 means. And you don't know either,
No.
quite frankly.
No, Your Honor, I completely understand.
You just say, okay, this is what they told me was due.
And that's exactly what we receive, usually you get from the bank.
Correct.
The bank will request that from the previous management company, and then they give the information to the bank. The bank, once you have the receiver, they just get all the paperwork from the bank. I completely understand where you're coming from, but that's usually how we research. I would say, can you please give me a copy of that check, front and back, so I can see where it was cashed. If it was cashed with us, it's easy to trace it in our internal system. If it was cashed with the other company, that allows me to go back and say, hey, this check was cashed with the other company. We need to do a little bit more research.
So I guess my question to you, Ms. Lee, is this. Chase. Can you go to Chase?
Mhm.
And I'm gonna give this back to you. And ask them for a copy of the front and the back of this check number, cashier's check, so that you can see who, if anybody, cashed it and what system, what bank it ran through, what account. It'll say all of that on the back. That's gonna help us kind of clear up. We still don't know what the 3825 goes to because this is the bad part of this receivership issue. Somebody could say, well, you know what? I paid the such and such dog fee. Let's just take something out of the hat. And you say, well, yeah, no, they didn't. But it was included, whatever they did was included in this. But we don't know if the dog fee was in there or not. And we don't know what this 3825 really stands for. And so a person has the right to object and say, well, wait a minute, I think I paid this, or I know I didn't pay this. You don't know either way what they paid, except for there's an outstanding amount, there's a total. And that makes it very difficult in a trial for you to even show what you received from them, except for a flat amount.
What company, when was receivership taken up?
October 19th.
It was right around the time that all this happened.
That's why I was asking for a copy of the front and back, because as I said.
We'll get it.
We have these into the property, so if I had a copy of that check, I could take a look.
Now, you know what? And I don't know how long, everything's fairly quickly these days, but I don't know. So I'm gonna adjourn this over for us to get this copy because otherwise there's no other issue. We know the 9,200 wasn't paid from whatever that date forward, and you need to figure out what you're gonna do about that because you know they're gonna have a judgment for at least that much.
Mhm.
And it could be more or less. I don't know. Just depends on what happened with this 4,000.
And just to be clear, I've always paid with a cashier's check. So there's another one I just randomly picked from out of my budget.
Okay, so I'm gonna give you this one back,
Okay,
and we're gonna come back, and I really want you to have some conversation first. What's your name again?
Dorian Montgomery.
Miss Montgomery is at the office now. you could get a copy of the front and back and take it into her before the next trial date. Let her take a look at it, get a copy of it. She can start her research as to, well, what happened to it? If we got it, it says we got it. Where is it? That way, when we come back, she'll be prepared to let me know what she found. Yep, you're right. She paid it. I couldn't trace it, but I know we got it somewhere, or she paid it, and I know we did get it because I can say it went to this account. So this is what's due now. She'll be able to at least say that, and maybe we can all agree on something
Okay.
without actually going through the whole trial situation.
I think I just one question for Ms. Montgomery. Yes, yes. Do you all have a system now that's up to pay your rent?
You can pay your rent in the office with, personal check, cash, well, though we have cashier check.
Okay, online.
Yes, absolutely.
What's the system? Because I went to all three of them and to try to see if I could see some ledgers. The only one I was able to pull up was the one that showed the ledger that I actually have. But then you also have the new one, and I wasn't able to log into it. It gives errors, so.
You can stop by the office, we can help you out with that.
Okay. Okay.
Okay, how many weeks?
Just want to make one possible suggestion. So we're in agreement that the 9270 is on. Can that be paid by the next time we come back as a condition? Because she's
The
already
condition of what?
well, she's already acknowledged that she owes for November, December, January, February, March, and April. So there's no contest about that. So it seems if we're holding on to the $4,000 payment itself to see whether that was applied to the 3825 arrears, she still owes all of that. Is it
Yeah.
possible that a judgment can enter today for the amount that she's acknowledging if she doesn't?
No. That defeats the whole purpose of researching the 4,000. You gonna get your judgment next time.
Claiming that she's paid that.
I know, but ma'am, Ms. Shaw, then what about the rest of the money that she might have a credit for? We gotta get the right amount for the judgment.
She's not claiming that she had a credit for November or onwards, but I understand, I'm advocating for my client.
Yeah, no, she's not, but I don't really know what the other balance prior thereto was. You said it was 38 plus another 92, right?
Well, she did it.
3825 plus a 92 something.
She's acknowledged she paid nothing for November.
Okay, ma'am, but I'm not gonna give a partial amount unless your client wants to waive it. So let's just say, your client will waive let's just say she does owe the 3825. Well, if you had a judgment today on that, it's waived. That 3825 is gone. And you're just gonna get the rest of it.
See,
Oh.
let's make the phone call. We'll be right back. Thank you.
Mhm. And if they waiving that amount, then they waived it.
This is the kind of bull crap that we going through with this. It's a lot of elderly people. They're making them pay not contracted.
Hold on, wait till they come back.
Relax, man.
It's a mess. I tell you, I feel so bad, but I am moving. I am.
Well, ultimately, when they come back, that's what they're trying to do now is get a judgment for the outstanding amount that you do agree you owe, the 9,000. If you pay it, you don't pay it, you move. So. That was quick, Ms. Shaw.
She's gonna just call. now.
Oh, okay. Oh, this is her ledger too. Give that back to her.
Oh, I gotta wait till she come back in. Before I
I
see-
don't know what they're doing. They're making a phone call to see if they want to waive any claim about the 3825. We still got the issue of what happened to $4,000.
Oh,
But we will just assume that they're gonna waive it, the 3825 of it, they're waiving, and you still would have arguably a credit of $100 and some or so towards the 9,200. Because when you got 4,000, you say you paid, they're saying $38.25 was due. There's $175 difference there.
Copy of the letters you want to see it. Is it okay to have?
I don't need to say it. This is you all trying to work this out. My suggestion is what needs to be done is to find the exact amount that's due. Let her see if this thing went through your system or not. Give her credit for it. Subtract it out, come up with the right number, and in the next week or so, give her a judge. At this point, what difference does it make? You're gonna get a judgment. We know you're gonna get a judgment.
This is like the third attorney, first attorney that came here, I showed him paperwork. He's like, oh, I didn't know that, and he said, well, we'll discuss it. The second time, they had a different attorney. She didn't know what was going on, so now it's, what's her name?
Shaw.
Ms. Shaw. She's here saying, okay, well, we know, we didn't even know you were disputing the $4,000, but you owe for 4 months. Let's get to the real issue. The real issue is, I wanna be credited for what I paid. That's all. It's nothing personal. If you were in my shoes, you would be doing the same thing. I'm not gonna give you $10,000 when I only owe you maybe 8.
She's never said that there's any credit that's owing for November ever. So there's no 8,000 that's owing, the base.
This is why we need to adjourn this and get the right number. I'm
Yeah.
telling you. Cause even to enter into this, she has to agree to whatever you're trying to do today anyway. Doesn't sound like she is, but
And I would feel more comfortable because it seems as though she's fixated on.
she's
what I
trying to
owe
get
her.
a judgment.
She worked with her company,
Exactly.
you know,
That's what.
I get that.
Mhm.
But on my side, I wanna make sure what you're asking me for, because I don't want you to come after me later on saying, oh, and about that $4,000, we want that too. No, because you're not gonna get it.
Why has there been no payment since then?
Okay, who cares?
Well,
We don't care. We just know there hasn't been.
say something.
I don't know why. Maybe she don't have it. Maybe she's gonna move. No.
Got hers.
All I know is your client's gonna be entitled to get a judgment. That much is clear.
Careful car accident.
And that's right, cause we did just have the, she thought it was for today's hearing, but it's from the last hearing, a police report that she submitted. That's why it got adjourned. Yeah. She was in a car accident.
Believe me, I have not been avoiding this. Life happens. And I will let you know now, I will not be living there. I will be moving out because it's a poorly kept building. I'm sure you've never been there, but.
When are you thinking of moving?
The end of the month. I am out of there because they're trying to.
Well, there you go. Your client's gonna want possession by the end of the month. If we came back and got the right amount.
Yeah.
In 2 weeks.
Yeah.
Still before the end of the month.
Mhm.
We can put the right number on the judgment. She can either pay it or move. She's saying she's gonna move. Your client gets possession back. Everybody's happy
One of the things that.
or unhappy, as the case may be.
I'm not happy with is the fact that they're trying to recoup money from Contour, was the previous owner. So now they're coming up with this, you have to pay a water bill. When I first moved in there, we didn't have any utilities to pay but our lights. Now you have to pay water, but this to catch. They're telling people, it's starting in March, you're gonna have a water bill, but one of my neighbors got a bill from December to January for $400 because they're trying to recoup the bill that Contour or the water company, because we called the water company. And they said, we do not have any individual accounts for any tenants there. This bill is in Contour's name. So they need to go after Contour. So they think some of the people in this building is stupid. We're very smart and very organized, and these people are on top of them. These people have not come one time and introduced themselves as a receivership. They have not met with, these people is finding out stuff as it comes along. And then the office is a joke. This is the third leasing person. They fired the one that came here because she was stealing money. And she probably stole that
We
check.
still on the record?
Yeah.
Let's go. She probably stole that check that I had because they fired her. The first person, when we first came to court, They fired her. And then they hired somebody else and they fired them. And now I've never seen her before. She said, what, 2 weeks?
Wait until my witness is back so she can hear these things. If we're gonna be on the record and this is going into the decision, I'd like my witness to be able to respond to these allegations.
I don't know what we're doing because I'm not making any decision based upon these allegations. She's just talking out of frustration.
Very frustrated. People are paying, when I moved in there, people spend $1,500. And even, I'm not even in a lease with them. My lease was up in 2024. And so I'm not in a lease with them. I could have just jumped ship and said, forget y'all. A lot of people are moving out the building. Now they're running a 999 special for new people, and the people that's in there, they paying like $1,700. The place have roaches, bad bugs, water floods, and all type of stuff going on. The elevator doesn't work half the time.
She wanted you to
And
hear
I
it.
am, and I tell you, I am gonna blast them. I am going to go to social media about this apartment because it's a shame that people that look like me are being treated like this. These people that has retired. And they love living there because they got to know each other over the years. And they treat them like crap. They treat them like crap. The management is horrible. Nobody's come out and talked to them and had a meeting. All they want is money. And some of the elderly people just go ahead on and pay the water bill. Why would you pay that $400 water bill? You haven't used $400 worth of water.
Your Honor, I had to object. She's talking about people who are not here, who she cannot speak for.
But I can speak to it because they tell me.
This is not, this is not.
Well, this isn't really, she's just blowing off steam. We're not,
It's all, we have to respond in some way because this is all a matter of appeal and so.
it's not appealing what? We're not in a hearing. We're not taking testimony. I'm not making a decision based upon what she's saying.
Next time you stepped up to this podium, you've been smug with me, looking down your nose at me. Look, I'm a very intelligent Black woman. And I know smug when I see it. I work with one every day. But you're not gonna come in here and just over talk and say, well, it's about, well, what about the November? You ain't even here. I've been in a car accident. You didn't even flinch one ounce of empathy. Like, I'm sorry, Miss Lee, you were in a car. I could have been killed. You said nothing. So when you talk about
Ms.
they're
Lee,
not here and all of this,
calm down. Cut it.
I'll tell you, I am like at 10.
So where are we?
It's just off back in, I'm sorry.
Wrapping up here.
I spoke with my corporate office. They said if she can bring a copy of that check, they will waive the $38.25 to get the judgment today for them later.
If she can bring a copy of the check.
They would love to get a copy of the check so that we can trace it, but they will waive the balance so we can get a ballot, so that we can go ahead and have the judgment on the ballot. So waive the $38.25 so that a judgment can be.
No, you're gonna waive $4,000.
Yeah, because she,
Check it, how you
You
gonna
will
waive
get- you will get-
$38,000?
And then we'll credit $1,000.
yes, she got 175 toward,
175
towards the rest of the what to do.
That's no problem. We'll go ahead and do that and we'll go ahead and enter a judgment today if you see fit.
So what they're saying, if you want to agree to it, is that 38.25 that they were carrying from the past back in October, they'll wipe that out. That would still owe 175, would take you back up to 4,000. They give you credit against this 9,200 of figure that they're saying you owe. They subtract the 175 off of that and take a judgment for that. And that would be what would be due up through April.
Okay.
And then they can't come back and get anything because the judgment is gonna be through April.
Okay. So at this point, Your Honor, I just want time. I'm asking time to move.
Okay. Have you given your notice that you're moving?
I'm giving it now.
Okay.
I want time to move.
You know, you're supposed to do that in writing. A 30-day note, it's supposed to be 30.
Until the end of. Okay.
So that would be, so how much is it, Ms. Shaw?
So the amount that was owing less so it was 92.70, subtracted 175, that takes it down to 90.95.
Okay,
176.04 in costs. So it's 90.95. 176.04 for a total of 92.71.04. And she would, if the payment she'd asked for end of the month, that would be April 30th. 2026. I change it from a hearing to a consent. And there's no money judgment on this one.
right. So ma'am, do you understand what's going on? The amount would be 90.95. That would be just the amounts that are due since you have agreed that you owe. That would be wiping out the 38.25, giving you another 175 credit to get to the 90.95 because it was 92.70.
So November, April equal 92.70.
Okay, can they make a copy of that for me?
Yeah, you could have.
You're gonna get a judgment.
So 92.70 minus 175 is 90.95, which is listed here. Those are the court costs there. 90.95 plus 176.04 is 92.71.04. And then we have it till April 30th, and since we don't have an attorney with you today, if you felt that you mentioned it's just Friedman error, you have 3 business days to support the same. So there's no money judgment, and if you wanted to stay, the full amount would need to be paid. If you stay beyond this date, then you could be liable for what beyond that date.
You got 3 days from today's date to ask me to set this consent agreement aside. If there's something about your rights that you're giving up that you don't understand, or something about the judgment that you don't understand when you get home. So do you know what rights you're giving up in a non-payment of rent case?
So this is, if you're in agreement with all the terms, we can go over again.
No, I'm good.
Okay, I have a role here, please. I have to go over this with her on the record. I gotta do it, not you. So do you understand that you have certain rights in a non-payment of rent case? I don't know if you ever watched an advice of rights video. Have you ever seen one? Okay, well, rather than play it, I'm gonna go over the rights with you. See where I put my little folder.
Oh, you mean the video that you showed at the beginning? Yes, I have seen it.
Oh,
Judge Johnson.
You have seen it?
Guys. Yeah,
All
I've
right,
seen it.
well, I'm gonna try to see if I can remember to go over everything with you. I don't know what my little folder is on it. What is it? I know it off the top of my head pretty well, but here it is. We got a right to have a lawyer to represent you. And of course, you've been here prior to today. So you could have asked for an adjournment to speak to a lawyer, but we're at the trial stage now, and we've been at the trial stage each time. But you had a right to ask for an adjournment to speak to a lawyer. You have a right to have your case heard in the place or the district where the property is located. You are in the correct district because Park and Trowbridge is in the jurisdiction of this court. But if it wasn't, you could have had it transferred to the proper place. You have a right to have a jury trial. Of course, you would have had to ask for a jury trial upon your first appearance, or at least file the jury demand within 5 days of your first appearance. And it was a form that you would have to fill out asking for a jury trial and pay the jury fee, unless it was waived. And you could have filled out a waiver if you couldn't afford the $50 jury fee. You have a right to ask for assistance to see if you could potentially get assistance, and that would be to ask for an adjournment to apply to some of the resources that were in that advice of rights video. And we would give you up to 30 days worth, really 28 days of adjournments to see if you're eligible for any type of assistance. And there's forms that you would have had to fill out. And those were white forms called a DC 539 form, which just tells us that you're going to apply for assistance and where you're applying. And when you fill it out the second time, it tells us the update of your application. So you're waiving your right to do all of that. And if you were going to do all of that, it should have been done really on your first appearance here, okay? But we're already here for trial. but those are the rights that you would have had. You had a right to reach an agreement by mediation outside of actually going to trial, which would have been what we call community dispute resolution. You could have requested that, and an outside mediator could have looked at the issues and made a decision if both parties presented their information, and both parties would have to agree to what that decision would have been. That could have resolved the case short of going to trial. You have a right to try to negotiate a conditional dismissal of the case as well. That's where you agree to do something, and if you do it, which is generally paying the money upon the agreed upon time frame, the case is dismissed immediately, conditioned upon that payment. And if, of course, you make the payment, the case remains dismissed. If you don't make the payments pursuant to the agreement, the case is reinstated. A judgment is entered against you with an immediate writ to evict you. So you have those rights as well. So those are generally the rights that you have in a non-payment of rent case. And by entering into a consent judgment, you generally are waiving those rights and just saying, hey, I want to resolve the case by this way, entering into this consent agreement. So you understand all that? And you know you're waiving those rights. Okay, so now, as she said, you do have those 3 days to ask me to set the judgment aside, but it has to be because there's something that you didn't understand about your rights or something that you didn't understand about the judgment. You'd have to file a motion to set it aside. We'd have to come back and have an argument on that. Typically, if we were going to set something aside, the remedy would be to go to trial, which is where we're at right now anyway. But you're opting to do this rather than go to trial, correct? Okay, so, and you understand how you got credit for the full $4,000, $38.25 of which towards the prior balance that they were claiming around the October time. And then the other $175 goes towards the balance from November on, which brought you down to the 95 plus cost of $176.04 for a total of $92.7104, with a move out date of April the 30th or a payment date. So you pay, you stay. If you don't pay, you move by April 30th. Any questions about any of that?
No,
Okay,
no, Judge.
good. So you sign the judgment. She'll have to go back and scan it in to have me assign it electronically, and then it'll come back to you. And, don't forget, leave your forwarding address in writing. Okay, within 4 days of your move, so that they can send you any damages sheet that they may have. Okay? We're good?
Just need the signature.
Oh, go ahead, ma'am. Well, good luck with your new position there. You're gonna have a lot going on.
I've been in this for a while, so I've done.
Okay. Always tough walking into, situations with receivers.
We should just, find what you can find, do research.
Now, they say they would like to trace that. So if you can go and ask your bank and just take it in
I'm absolutely going up to my bank.
and ask for copies of the front and back and just,
Got me intrigued about who did catch that check. 'Cause
Yeah.
it's a
yeah.
lot going on.
Okay.
Somebody might have got a little leaky finger. I'm like.
Well, let's hope not.
I
All
hope.
right, well, that's gonna complete this matter. Good luck.
Cashier, there's nothing with it once it's rolled out.